Hey everybody, it's Mike Kennedy. Welcome back to my garage for part 3 of the little 15-minute pieces that are chock full of legal ethics and professional responsibility that I've been doing over the past day or so. You're going to want to follow along on my blog, VTBarCounsel.wordpress.com. Look for the tab that says PR Madness. Once you're at that tab, look for the link to full bracket. And so while you're getting there, you might want to pause and check out parts 1 and part 2 first. Part 1 explains what we're doing here, why my car's here. That's my car. Why those beer cans are up there. Part 2 explains why I'm wearing my UVM gear while I do these little segments. My vest, my hat, the shirt that we would have worn to the America East Championship game. Remember for me, this is supposed to be in fun. It's supposed to be a diversion from all that's going on with coronavirus and self-isolation and quarantine and the stress and the anxiety, and we just don't know what's happening. So not only is it a diversion, I'm using the diversion to try to provide some guidance on legal ethics. If you don't like the format, don't keep watching. Turn it off. Please don't send me an email complaining about this. The first 2 of these segments I've done already are online. I've tweeted them. Somebody already emailed to complain about how I'm dressed and why are you doing it so informally and why is it only 15 minutes. I really don't know what to tell you, dude. I don't. I have a lot of thoughts in my head about what to tell you. I'm not going to tell you, so I'm just going to say I don't know what to tell you. Anyway, if you're there, you'll see that what I've done is parodied the NCAA bracket that we usually are or a lot of us are participating in this time of year. Tournament's been canceled. So instead of basketball teams in there, you'll see rules, thoughts, concepts associated with legal ethics and professional responsibility. So what I'm going to do, like they do on TV or talk radio when the real basketball bracket comes out, I'm going to analyze each of the quadrants, tell you which ones I think may advance far into the tournament, which ones might get knocked out early, which ones are sleepers, like upset specials, which ones are overrated. Little brief thoughts on each of the participants in the tournament. So here we go. The upper right quadrant, the top seed in that bracket, the duty to communicate with clients. Duty includes giving a client sufficient information to make informed decisions about the representation. Duty includes responding to reasonable requests for information from the client. Requests from the client for information about the representation. Remember, I said it last week in my video, Sailing the 7 C's of Ethics, and I say it all the time at seminars. It's not the, I forgot to call you back, I forgot to respond to your email, that's going to cause the disciplinary complaint. It's the failure to set reasonable expectations early on that's going to cause the complaint when later on, because you didn't disabuse a client of unreasonable expectations, they don't get what they thought they were going to get, that you knew they were never going to get, and then they file the complaint. That includes how long is the case going to take? What's it going to cost me? How often will I hear from you, my lawyer? Things like that. Communicate reasonable expectations up front goes a long way to avoiding disciplinary complaints. Matched up in the first round, IOLTA or not. I understand this came up on the VBA Connect last week. I'm not really sure of the context in which it came up, but remember, in Vermont, if you're holding funds in connection with a representation and they are not reasonably expected to earn net interest or dividends as defined by the rule, they go into your IOLTA, not into an account where the interest goes back to you or to your client, into your IOLTA. It's rule 1.15 capital B, and that's all together. It's not 1.15 then subparagraph B. The capital B is in the rule. Check out that rule. Give me a call if you're confused. There is nothing in the rule that says, well, it's only if it's more than $50 in interest or $100 in interest. There's no limit like that. Remember also your IOLTA account has to be at a bank approved by the Professional Responsibility Board, and the list of those banks that have been approved are on our website. Disputed funds versus client or lawyer makes the decision. The 8 seed, disputed funds. Rule 1.15D, what do you do when there are funds in trust that are your clients, but somebody else asserts an interest in those funds? Most often comes up in my work with some medical provider who has provided care and wants to get paid for that care once the personal injury settlement funds come into the lawyer's account. Could also be the lawyer who is asserting the interest in the funds. Remember, no matter who's asserting the interest, if it's a valid interest that's being asserted, and I've blogged about that, search for it on my blog, you have to keep the funds in trust until the dispute is resolved. Remember, you also have to disperse any portion that's not in dispute. So let's say you get $1,000 in there, and there's no doubt, even client agrees that you did $500 worth of work. You think you did 1,000, client thinks you only did 500. Pay yourself the first 500 that even client concedes is yours. Otherwise, that's commingling. And finally on that, remember, it's not just some random person who can assert an interest in funds. So let's say somebody owes me money because they lost a bet to me on the NCAA college basketball tournament 5 years ago. And then yesterday, they got a personal injury settlement and it's in your account, your trust account. I can't just then assert an interest in those funds because they haven't paid me. The number 9 seed in this bracket, who makes the decision, client or lawyer? Rule 1.2a, the objectives belong to the client. The means by which those objectives are pursued, reached, are the lawyers in consultation with the client. Remember, the client always has the authority to settle. You don't have to put on every witness the client says. You don't have to take every deposition the client says. I see that often in criminal cases where a lot of pressure is put on public defenders to call this witness, to pose that witness. Remember, those are means by which the objectives are pursued. Number 5 in this category, client under a diminished capacity. I apologize, the little bobcat that goes around the neighborhood plowing the snow is going by right now, smashing into the driveway. Client under diminished capacity. Whenever, it's rule 1.14, a client's ability to make adequately informed decisions about their representation is diminished. Could be from being too young, you've got a kid, being too old, it could be somebody with mental health or substance abuse issues. Whenever there's a diminished capacity, you have to try to keep, to the extent you can, as normal a client-lawyer relationship as possible. From there, there are some things that you can do that you normally wouldn't otherwise be authorized to do with a client who doesn't have a diminished capacity. I suggest you give me a call first because I think the rule sets a higher standard than most lawyers think, based that on the calls I've received. The 4 seed in this quadrant, trust accounting and bookkeeping. 1.15 capital A. Do you know the basic requirements that all trust account systems, your bookkeeping system, must have? I'm going to tell you what they are. You must remember, a trust account, pooled interest-bearing trust account, means that funds from all your different clients that you're holding in trust can go into the same account. That's your pooled interest-bearing account, your IOLTA, and then you have to keep track of them. You should always know how much money you have and who it belongs to. That's essentially what your system should show. The system at a very basic level must show all receipts and disbursements from the pooled interest-bearing account. Your system must also show all receipts and disbursements from each client account made on behalf of each client. The system has to show records documenting timely notice to the clients of money that comes in for them or money that goes out on their behalf. And finally, you have to have in your system records that document timely reconciliation, which our rules define as no less than monthly. Also, you have to have a single source, like something that says where all your trust accounts are. If you don't have those, you don't meet the minimum requirements. If you're selected for one of our audits that Sarah Katz's office does, that could pose some issues. So make sure that your system meets the basics, the minimum standards of the rule. And finally, in the upper half of this quadrant, flat fees paid in advance. We changed the rules a couple of years ago. It's rule 1.15, I think F. It's at the bottom of 1.5F. It's that says there are certain situations where when you receive money but you've not yet done any work, you can treat it as your own. and they don't go into trust. They are very limited. You've got to follow the rule strictly. Otherwise, the rule is what it's always been. I give you $5,000 as a retainer to handle my divorce. That's not a true retainer. Topic for another day. It's an advanced fee. You haven't done anything on my divorce yet. It goes into trust and stays there until earned. Take a look at Rule 1.15F, 1.5F, if you're handling flat fees, and make sure you're handling them correctly. Okay, moving on to the lower half of this quadrant. We get to the 6th seed, collected funds. Big one. I think this is actually a sleeper in this bracket. When can you disperse? When do you have collected funds? So it's Rule 1.15F. Remember, you can't disperse absent collected funds, but then we have several exceptions. Going back to the prohibition. The reason is, like, I have money in your trust account. Somebody else's money there's a deposit made for somebody else. You disperse before that deposit is good. Turns out it fails, and all of a sudden it's my money that's gone when your trust account check is cashed. That's a violation of the rules. There are exceptions. For instance, you can write against, on deposit, checks drawn on an account maintained by an insurance company licensed to do business in Vermont. IOLTA checks from other attorneys. IORTA checks from realtors. Personal checks, but only if the amount is under $1,000. Checks issued by the government. Take a look at the rule. It's in Rule 1.15. That's going against the 11 seed. Commingling, own funds in trust. Talked about it in the Sailing the 7 Seas of Legal Ethics video. It's considered a very serious violation to commingle. It's Rule 1.15a. Small a. So 1.15 by itself, then small a paragraph. It's funny how they number those trust accounting rules. Anyway, don't have your money in trust. If it's yours, get it out. Remember, you can put your own funds in, Rule 1.15 small b, but only in an amount necessary to cover bank fees and service charges. Remember, you can't just dump $1,000 in there and use it as a float to protect against overdrafts. The 3 seed in this bracket, duty to clients, file delivery, file retention. Get this call all the time. How long do I have to keep the file? Well, the rule says, it's Rule 1.16d, upon the termination of the representation, a lawyer shall surrender to the client papers and property to which the client is entitled. Papers to which the client is entitled includes the file. When the case is over, and I know this is hard, I know it's hard, but that when the case is done, A, I think you should be writing closing letters if they protect you. B, deliver the file. Then, whether you want to keep a copy or not, that's up to you. Your carrier probably wants you to. It's a good idea to keep copies just in case something comes up. Could be a disciplinary complaint. Could be the client has a question. Things didn't exactly turn out right with the settlement. You know, there's issues. If you don't deliver the file, a lot of lawyers, well, how long do I have to keep it? Completely up to you. Our rule is silent on that. You have to exercise some discretion, though, because some files may sprout up again, whatever the term would be, a long way down the road. If you do get to a point where you're destroying files, you should at least call them to make sure there are no important originals in there, like a will. You also should consider, I think, some form of notice. What do they call those things? The file, so-and-so is going out of business. If you want your file, come get it. But give me a call. This comes up a lot. I'll try to help you through it. Number 14 seed, mandatory malpractice. Oh, and going back to file delivery, we have not defined what the file is. My position is that we're an end product state, that your notes and work product don't have to be turned over. I base that on an old VBA advisory ethics opinion and an ABA advisory opinion. But I'm not positive that the court would agree with me. 14 seed, mandatory malpractice. This came up in an assistance panel. I sat on. 2 members of the panel were shocked to hear from the lawyer that the lawyer did not have malpractice insurance. One, a non-lawyer who was on the panel, was stunned to hear that we don't require lawyers to carry malpractice insurance. The board, the PRB, was slated to start looking at this issue in a couple days at its meeting that's set for Friday. It's not going to now because we're looking at other things related to the pandemic. But the board's going to look into whether we should adopt a rule requiring malpractice. Only 2 states have done that. Or if we don't do that, do what some other states have done, and that is require a lawyer to inform a client, prospective client, that if they don't have malpractice, that they don't have it. The number 7 seed in this bracket, tech competence. I put it in this bracket, duties to clients. The more competent you are in technology, and how it can make you just run much more efficiently, you actually can save your clients lots of money. Number 10, fee sharing and referral fees. Remember, it's in Rule 1.8, our rule on sharing fees with another lawyer who is not in the same firm. Client has to consent. Overall fee has to be reasonable. And then the fee that each gets, one of 2 things, either paid in proportion to the work done, or each assumes joint responsibility for the representation. And that means if something goes wrong, you're on the hook. I've blogged about that, look it up. We do not allow referral fees. You can't just pay somebody for a referral. That's in Rule 7.2, check it out. I've also blogged about that 3 times, 3 different times, all on that point. The fee sharing rule, remember, either paid in proportion to what you do, or you each assume responsibility for their representation. Diligence, competence, key, obviously diligence is too, it's its own rule. A lawyer shall provide a client with, shall act with reasonable diligence and promptness when representing a client. Used to get a ton of complaints on this when I first started, and I love to prosecute it. We used to prosecute it under the old rule that prohibited lawyers from neglecting client matters. They changed it now to make it more positive sounding. Be diligent instead of don't neglect things. But there are a lot of people in my world who think that this is the most critical rule, and that it's the lack of diligence, procrastination, is what gives us a sort of a bad name collectively. Related to that, interesting early matchups, succession planning, disaster planning. Unfortunately, issue right now in these times. Some smalls and solos, even some mid-sized firms, don't really have a plan. How are we accessing our client information? How are our clients getting in touch with us during an emergency? Big issue. Rule 1.3, the rule on diligence, suggests in a comment that all small and solo practitioners should have succession plans. We've not yet mandated it. Some states have. I've blogged on disaster plans. All firms should have that, some sort of continuity of operations plans. Anyway, that's the lower quadrant of this bracket. So, apologize if I rambled on a couple of those rules, but I'm not filming this one again. It took me like 4 takes, and I'm tired. I think that disputed funds is a very strong 8 seed in this bracket. I also think diminished capacity is one I get a lot. I think number 4 worries lawyers a lot. Over here, file delivery and retention, and that's where I started rambling. I apologize. Another big one, but go in, check it out on the blog, vote for the ones that you like, don't like, whatever the criteria may be. Thank you for doing this. I thank you for giving me a chance just to do what I feel comfortable doing, which is talking about legal ethics, especially if I can relate it to basketball, especially if I can do it in a casual environment. Thanks again. I hope you vote. Hope you're all doing well and staying safe. Bye.